Now let's bring in famed attorney and Harvard Law Professor Emeritus Alan Dershowitz. Professor Dershowitz is a Newsmax contributor, the author of Guilt by Accusation, the challenge of proving innocence in the age of Me Too. Professor, great to see you. Want to get back to the demands of CHAZ, that group in Seattle. These demands fell into four basic categories: the justice system, health and human services, economics, education. Many of the demands are reasonable, others not so much. Here's some of our favorites for you. Demanding the degentrification of Seattle, free college in the state of Washington, free public housing because they say housing is a right, not a privilege, socialized health and medicine for the city of Seattle. They are also demanding that autonomy be given to the people to create localized anti-crime systems, as well as the abolition of imprisonment. Professor, they stop short of asking for complete control of Amazon, but who knows? They might go there next. What do you make of this list of demands?
Well, we have a perfect storm that was utterly unpredictable. We have the coronavirus, massive unemployment, racial tensions all coming together. And inevitably, you're going to get a small number of revolutionaries, some on the right, some on the hard left, who don't like our system of government and will try to hijack legitimate, reasonable protests against excesses of police abuses and use it for their own kind of revolutionary means. The idea of abolishing the police is absurd. It would disadvantage poor people, people of color, more than anybody else. The idea of there being, really no property rights. The thing that was most upsetting is the idea that businesses have to pay a fee to operate. That, to me, sounds a little bit like extortion. If you want to operate safely, if you don't want to have your windows broken, pay us. That can't be accepted or tolerated in a decent society. Look, protests have to go on. They're legitimate. They're protected by the Constitution. But the Constitution also guarantees every state a Republican form of government, which means essentially a democracy. It means that the people have to rule and not the protesters, and certainly not those who can threaten mob violence. So we have to strike the appropriate balance, both legally and politically.
The president has run on a law and order platform, as you know, and sent out a tweet yesterday calling these protesters and anarchists, warning the Washington governor, Jay Inslee, and the Seattle mayor, Jenny Durkan, quote, "If you don't take back Seattle, I will." Does he have any legal standing? Can he take back that portion of Seattle, Professor?
There has never been a situation like that in certainly modern American history. The Constitution does provide that the federal government shall guarantee to every state a Republican form of government. So if you ever had an actual revolution like the Russian Revolution or the French Revolution or some other revolutions that would try to undo democracy, then there would be authority in the federal government, whether it comes through Congress or through the president, to restore democracy, but we're not there at this point. At this point, it's the job of local authorities, perhaps helped by the National Guard if requested, to restore law and order. And you can't throw together protesters and anarchists and mob violence. We have to separate them out. The First Amendment protects protesters, even protesters who are loud and obnoxious and ask for things that none of us who are reasonable approve of. They have the right to do that. What they don't have the right to do is threaten store owners. They don't have the right to take over areas of a city. And the line has to be drawn between what's constitutionally protected and what's illegal.
Let's hope the governor and the mayor are paying attention to what you're saying there. Professor, let's move on now to former National Security Advisor Michael Flynn. As you know, a court-appointed expert urging a federal judge to reject the Trump administration's attempt to drop the criminal case against Flynn. The expert, a retired federal judge named John Gleeson. In this massive 73-page brief, Gleeson slammed the Justice Department's, quote, highly irregular conduct to benefit a political ally of the president. He also accused the Department of Justice of, quote, gross abuse of prosecutorial power. What do you make of Gleason's language alone? I know you feel he didn't even have the right to be appointed by the original judge.
Well, let's first of all be very clear. He's not an expert. He's an advocate. He has been retained by the judge improperly, in my view, unethically, in my view, to represent the judge and to do the judge's bidding and to give the judge cover for what he wants to do. It's a very unusual proceeding. Look, the federal government, for better or worse, has the power to decide whether to go forward with prosecutions or to drop them. That's an executive power under the Constitution of the United States. Judges are not allowed to have any role to play in that power. Judges are not there to intrude on executive decisions. And so I read what Judge Gleason, who was a good judge when he sat in New York, but he's playing a role now that he should never have allowed himself to be used to play. He's an advocate for a judge. He's just another lawyer. He's not an expert. He has never been an expert. His background is not in constitutional law. He was a former mob prosecutor, and then he became a judge. But he's just like any other lawyer, and his views shouldn't be taken any more seriously than any lawyer who is appointed by a judge. I don't know whether he's paid by the judge, paid by the government. I don't know what the relationship is, but it's a very questionable role to play, to be appointed by a judge to argue for what the judge wants to have argued. That's just not the way our system of justice operates.
And the reason I mention the language, Professor, is it read like a New York Times op-ed, overtly political references throughout this 73-page brief. How much weight does it ultimately hold, and how do you think this case will be adjudicated? Michael Flynn did, after all, lie and admit to it, plead guilty under oath. Where do you see this going?
Well, no attention should be paid to it at all. It's just an advocate's brief. We'll have to see the other side, and then we'll decide who gets the better of the argument. But no special attention should be paid because he's a former judge and somebody called him an expert. He's not an expert. Flynn did not commit a crime. Flynn may have lied, but he did not lie about anything material to an investigation because the government already knew the answers to the questions. They had him on tape. They had him. They had the most definitive evidence possible that he had spoken to this Russian ambassador. The only reason they asked him the question was to have him fall into a perjury trap. That is not a proper use of law enforcement, in my view. And every civil libertarian should be agreeing with me. Every civil libertarian, if the shoe were on the other foot, if Hillary Clinton had been elected president and her national security advisor had been put into a perjury trap like this, the ACLU, every civil libertarian, every liberal I know would be saying, oh my God, that's an improper use of prosecutorial discretion and FBI tactics. We should be opposed to it. But because it's President Trump and because people don't like the shoe on the other foot test, they would rather be partisan. Many people who would normally oppose such a tactic now favor it.
All right, next heads to a 3-judge panel on the Court of Appeals tomorrow. We'll have the latest on that tomorrow on this program. Professor Dershowitz, great to see you, sir. Thank you.
Thank you.
You just watched Newsmax TV, America's fastest growing news channel, now in 65 million homes. Get Newsmax TV on all the major cable systems or go to newsmaxtv.com and click on the Find Newsmax tab to locate us. Remember, Newsmax TV, we're real news for real people.